we'll give just a few seconds here for our attendees to come in. It takes a little bit for everybody to come in. Hi, everybody. Welcome to CrimCon Stream 1 here on Wednesday, I think. We are here today with a panel titled The Continued Failures of Death Penalty Administration, How the Discretion of Prosecutors and Capital Jurors Reinforces Arbitrariness. A couple of things for everybody to keep in mind. The way that we will do this is we'll proceed in the order of the program. We've just changed the order of the program, however, so we'll have the project that you can see up on the screen here first. Each presenter will have 10 minutes to give their presentation, and we'll proceed pretty quickly. The way that questions will work, if you have a question, click the Q&A button down at the bottom of your window and type in your question. We'll answer questions after everyone has presented to make sure that we've got enough time for all of the presentations. You won't see your questions until after we've answered them, and we'll try to pick out the best questions. Please know that in the interest of time, we might not have an opportunity to get to all of your questions, but we do really appreciate them. We'll answer your questions at the end of the session, but you can ask them whenever you would like. In fact, please ask them as they come up. So with that, we will start with our first presentation.
Great. I hope that's showing up correctly. Thanks everybody for joining us today. My name is Heather Pruss. I am an assistant professor of criminal justice studies at Bellarmine University. That's in Louisville, Kentucky. And I'm going to be presenting today on essentially an update of what the most recent wave of data shows from what's been a 30-year effort to collect data on a project known as the Capital Jury Project. So this was an initiative started by Bill Bowers, a mentor and friend of ours who has since passed, but whose legacy we try to do our best to uphold and sort of follow through with this work of his. So CJP was initiated in 1991 by a group of university-based researchers, was funded by the National Science Foundation, and has gone through a couple different waves of data collection. The data come from 3 to 4 hour in-depth interviews with former capital jurors that we talk to usually a couple years after their service. And the interview chronicles basically every facet of their experience throughout the course of the trial. The goal of this project was essentially to determine if, following the Gregg decision from the Supreme Court, these revised capital sentencing statutes were doing their job in purging arbitrariness from capital juror decision making. I'll give you some more background on that legal framework in just a moment. But I want to finish saying sort of what the data is and what I plan to cover today. So phase 1, you'll hear me refer to as CJP1, was the first wave of data collection for this project that took place largely in the early to late 90s and resulted in interviews with about 1,200 jurors from over 350 capital murder trials across 14 different states. About 60% of those wound up in death and the other 40% in life without parole. Phase 3 is really what I'm going to sort of compare this to for my presentation today in the Indiana segment of that data in particular, because I have easiest access to that as someone who helped collect this information. You'll see that it's a much smaller number of jurors, only 153, but makes for some interesting comparisons. So in 1972, I'm sure many of you know that the Supreme Court struck down the death penalty largely on the basis that it was being administered in an arbitrary fashion. Justice Stewart likened this to being struck by lightning, talked about it being wantonly and freakishly imposed. And this was the crux of why the court said we can't do the death penalty anymore because we can't do it in a consistent way. Well, 4 years later, the Supreme Court revalidated the death penalty and various kinds of sentencing statutes known as guided discretion statutes. So states had gone back and revised their law to do the following things, or these were the components they had to have to again be constitutional. They had to consider aggravating and mitigating factors in the statute, so things that support a sentence of death and things that support a sentence of life without parole. They had to institute bifurcated proceedings, which means breaking apart the jurors' decisions into two separate phases, a guilt phase and a punishment phase. And third, that there needed to be a mandatory direct appeal to the state Supreme Court in that jurisdiction. So that's the sort of background for, what CJP was interested in seeing, whether or not those reforms were successful, right, in sort of removing or purging this arbitrariness from the panel, or excuse me, from the jury from jury decision making. So one of the watershed pieces that came out from the first wave of the Capital Jury Project data was this piece by Bill Bowers and Wanda Foglia that talked about law's failures to purge this arbitrariness from capital sentencing. They laid out these specific ways in which these failures were happening, that jurors were engaging in premature decision-making on punishment, that there was apparent bias in jury selection in terms of who was still winding up as serving on juries, and that there appeared to be a failure to understand instructions among jurors, coupled with an erroneous belief that in certain cases death was required punishment. Also that jurors tended to evade responsibility for making the punishment decision, and also that they were underestimating the alternative sentence if the death penalty was not imposed. So we're kind of hoping that, like, all right, if that's the first phase of data collection, we're talking the 90s, the death penalty's heyday in terms of the number of cases and the volume that's moving through the system, maybe things look a little bit different now, because the death penalty and its imposition, or how often it's sought and in what kind of cases, has certainly changed, as well as the practices of capital attorneys. So maybe things have improved, maybe things have changed. That's kind of what I'm looking at today, is this comparison from what CJP1 tells us and what we know from the most recent wave of this data. So as you can tell from the title on the first slide and the rest, we still see that jurors are engaging in premature decision-making. Just for context, so this is the percentage of jurors who said they had decided on a punishment prior to the punishment phase, but after the guilt phase. So now that there's this bifurcated proceeding, it's supposed to be two separate decisions. For context, the number of undecideds in that column, if jurors were capable of following the law, would be 100%. You can see that it's not, right? Less than half of jurors are undecided at the moment that the law tells them that they have to be undecided on punishment. And you can see that of those that have decisions in mind, they are leaning pretty substantially toward death. Just as a quick sort of follow-up to this is just for that little chunk of data I've highlighted there, but the next question we asked jurors, well, but how strongly did you feel wedded to that punishment decision? And you can see that over 72% of jurors are saying, I was absolutely convinced. So that doesn't bode well for a democratic process during deliberations on punishment, right? If you're walking in with jurors that are already absolutely convinced of what they think is the appropriate punishment decision. We still see that there's bias in jury selection. Again, if jurors were capable of following the law, the numbers on this chart would be zeros, because this is the percent of jurors who say they would consider death the only acceptable punishment for the following types of murders that we pose to them. Keep in mind, these are jurors who served on cases, were vetted through what we call death qualification processes. This is a sort of whole nother phenomenon that we know results in jurors that are more likely to not only be conviction prone, but death prone. And jurors that we talk to that should have been weeded out from this process clearly are not. They are telling us, I consider death the only acceptable punishment for these kinds of crimes. They should by law not be eligible for jury service. And again, those numbers should be zeros. There's also a failure among jurors to understand the directions in terms of how you consider and weigh mitigating evidence that supports a sentence of life without parole, and aggravating circumstances. These are circumstances that support a sentence of death. You can see there are a myriad of ways that this is happening, but jurors are failing to understand that they were allowed to consider any evidence that's mitigation, that they don't have to be unanimous in those decisions, that they didn't have to find that evidence proven beyond a reasonable doubt. But on the other hand, aggravation must be proven beyond a reasonable doubt. They're misunderstanding this. And also that they could consider only a specific list of aggravation. Jurors are fundamentally misunderstanding. It's also notable that these are all in the direction of persuading the jury more toward a verdict of death on punishment rather than life without parole. So the implications of these misunderstandings are not ones that benefit the defendant. There's also an erroneous belief that death is required in certain kinds of circumstances by law. This is never true, but jurors are telling us then and now that if they considered the defendant's conduct to be heinous, vile, or depraved, or that the defendant would be a danger in the future, that the law required the death penalty. Those numbers should be zeros. We also see that jurors tend to minimize their own role in making the decision that ultimately leads to the presumptive carrying out of a death sentence for a defendant. So when we ask jurors who was most or what was most responsible for the punishment that was imposed, again, across time, we see that the overwhelming onus is put on the defendant, right? Because their conduct, according to the jurors, is what determined the punishment. Now, as I've said, the law is never going to require death as a sentence for any crime. It can become an option if the certain circumstances are met, but it's never a requirement. We see they next sort of point to the law as what determines this. And then in sort of descending really small chunks, they'll say the jury as a whole, themselves as an individual juror, and occasionally the judge, as that where the sort of crux of that decision lies, despite the fact that the law and defense attorneys will try to make very, very clear that the individual juror is where this ultimate decision resides. And lastly, jurors underestimate what's going to happen in terms of a length of sentence if the defendant isn't sentenced to death then and now. You can see that there's been a bit of a change here between this first phase and most recent phase of data collection. In fact, this is the most notable change that I've seen across these tables. But it's still worth noting that 25 years is really, really, really the absolute bottom of the end of the possibility for a murder case. So in Indiana, for example, a murder charge that doesn't result in death or life without parole carries 45 to 65 years. Say that you get sentenced to the very bottom of that window, 45, and you get all the good time you possibly can. So you serve half of your sentence. That's roughly 25 years. So that's like under the most extreme perfect circumstances, the sort of least possible time someone could serve. And that's the median estimate of what people are saying someone not sentenced to death will serve. The reason this is extra consequential is because if jurors are likely to underestimate this number, they are also more likely to impose a sentence of death. We've sort of run the data on that with the existing CJP information. So in conclusion, I wish I could say that things have changed, right? And in some ways you would expect them to, given how things have shifted with the death penalty in terms of its use, how things have narrowed. Defense attorneys and judges are aware of this data because it's been around so long and have sort of changed their practices accordingly. But we don't see that change happening. We see the jurors continue to misunderstand and misapply the law in ways that do not advantage the defendant, in fact, disadvantage and make a death sentence more likely. So in terms of whether or not these guided discretion statutes have been effective in purging arbitrariness from capital jury decision-making, we can pretty definitively say that is not the case, and can just sort of add this to the list of all the reasons most contemporary legal experts and scholars would tell you the death penalty is really still unconstitutional as it's being practiced. That's it for me. Thanks for your attention.
Great, thank you so much. Next. You finished just early enough to catch me not looking at the program. Next, we have Sara Walsh. And Sara, it looks like you may be muted.
Yeah, give me 1 second to get these up and running. Okay. How does that look?
That looks great.
Great. Okay, so I'm Sara Walsh, and this is juror decision making in capital cases with subsequently exonerated defendants. And I'm also working from the Capital Jury Project on this. So I'm not going to cover the CJP design because Heather did that. So I'll just answer any questions you have at the end. What I set out to do here was to understand what we might learn about decision making of jurors generally, and in cases specifically where they were later exonerated. So of special interest here is obviously how a jury overcomes doubt and processes evidence in these cases. I was also interested in what might be very different or telling about these cases from other cases. So we don't have a lot of cases here. First, we identified exonerations in the capital jury active states. And then we matched the cases based on the details. And so in the end, I ended up with 2 cases identified as exonerations that were part of the Capital Jury Project. That's a total of 8 jurors interviewed, and it worked out to 4 per case. In the quantitative data, we have over 800 variables. We ran crosstabs on 113 based on themes of evidence, guilt decision-making, and juror dynamics and composition. I then looked at which variables were very different between jurors on exonerated cases and the other jurors. Keeping in mind throughout that we have 8 jurors interviewed here from exonerated cases. For the open-ended questions and additional narratives captured in the interview, I first looked at specific questions dealing with guilt, doubt, and the use of evidence. This didn't yield much because of the way jurors tell their story across the interview. So I moved to open coding and analysis of the transcripts, starting with the themes of doubt, guilt, and evidence use. What evolved with themes of poor defense, poor evidence, juror feelings about the defendant, including racism and disgust, and also feelings of familiarity with the case and a lot of juror confidence in their decision making, but not necessarily the death penalty. So this is from the quantitative. This is what was very different and where the jurors on exonerated cases were higher than the others. So we're looking at between 6 and 8 responses from the exonerated jurors and around 1,100 from the others. So interpret with caution there. One person is about 12.5% on the exonerated jurors. So these are what follows. This is the most interesting, I thought, from the top 25 of the 113 I ran in terms of the size difference between jurors and the exonerated and the other jurors. So number 1 here, we see that jurors on exonerated cases were much more likely to report that the defense claimed no role in the crime. And that's not surprising because these are exonerated cases. And also that on number 2 here, jurors on exonerated cases were much more likely to say that no juror voted for a life sentence on the first jury vote. On the 3rd, we see that jurors on cases of exonerated defendants were much more likely to say that the defense relied on an argument that the state had not proved the defendant guilty beyond a reasonable doubt. In the qualitative later, we'll see that the jurors speak to the absence of a defense case more generally here. On the 4th graph here, we see that jurors on cases of exonerated defendants were much more likely to say they did not discuss if the defendant was guilty of murder, but not of capital murder. And on the 5th one here, jurors on cases of exonerated defendants were much more likely to say that everyone voted for death on the first jury vote. And on the last one, on number 6, we see that they were also more likely to say that the possibility that their punishment decision being overruled made them feel bad because the defendant might not get what they deserved. So this is not surprising based on what we know about death qualified juries. On the next slide, I've got what was very different, and again, the most interesting ones, according to me, in terms of what the jurors of exonerated were lower than the others. So jurors on cases of exonerated defendants were much less likely to say on number 1 here that there was no formal confession presented, and on number 2 here that there was no testimony of an accomplice or a co-defendant. On number 3, we see that jurors on cases of exonerated defendants were also much less likely to say that no one was undecided on punishment when the first jury vote was taken, meaning they were more likely to have undecided jurors on the first vote of punishment. On number 4, we see that they were less likely to recall a witness testifying to a motive. And on the last one, that they were less likely, so that's 0 people, to say that someone testified that they had seen the defendant commit a crime. I also kind of looked through these to see where we might have expected to see a difference, but did not. And 2 that stood out to me was the question was any testimony at the guilt phase hard to believe? And you don't really see a difference here between the jurors of exonerated and the other jurors. And the other one here is whether or not they had the jurors of feelings of guilt before deliberation. And you don't see a difference here in terms of the jurors of exonerated and others in terms of thinking about not guilty, right? They look pretty much the same. Okay, so on to the qualitative. So looking at these, we see common themes emerge. The defense in both cases was weak and did not offer alternative explanations or a story to account for junk evidence and circumstantial evidence. In the absence of an alternative narrative, the jurors really individually created their own narratives to connect the dots. They relied heavily on their impression of the type of person the defendant was and filled in the blanks with motives, relationships, and evidence not presented in court. Mundane events such as paying back rent became really key pieces of evidence to the jurors. I'll talk about the jury makeup, but one of the more obvious takeaways from this is that adding people of color or women to the jury just can't make up for a poor defense. So in the interest of time, I'm just going to show you a few quotes from jurors and just ask you to ask questions at the end. So one of the themes that emerges, it was just a picture of, this is case one, of a jury that really wanted an alternative explanation from the defense and just did not get one. And they could not construct an alternative story that accounted for the evidence. In the first case, we see that the jurors did discuss the meaning of proof beyond a reasonable doubt. And so you'll see, on that third quote there, she says, as a Black juror with a Black defendant, I wanted to believe in the defendant. I wanted to be sure he was not used as a scapegoat. And kind of throughout her interview, she keeps indicating, I really wanted to have some other way to piece this together. On case two, no juror mentioned it, but neither defense attorney had any experience with the criminal law or trials generally. They did note that the case was built on the argument that the state had simply not proved the case and that some of the techniques had backfired. In the second case, jurors are convinced by evidence presented by the prosecution that the shooter must have been left-handed. And this is one of the things that these jurors keep talking about is that the left-handed argument was incredibly compelling and they just couldn't get away from it. So in case one, they talk a lot about the physical evidence, but it's all circumstantial. And so again, you see just that there's no defense narrative that can move around what they see as really powerful, if bad, evidence. One of the really outstanding themes here was, this reliance on their idea of the defendant. And unfortunately, we saw a lot of racism. And this is case one, which had a pretty diverse jury, and the foreperson was actually a Black woman. So this is one of the jurors just attributing the motive of the crime. I think the last quote on here really sums it up. He says he made up in his mind that he knew it exactly what had happened. He wanted the shiny evidence and he wanted it to save it instead of throwing it away. He wanted it because it was a pretty shiny one, and that's just typical of them. And so this is just one example of how basically just using an impression of the defendant to fill in the gaps that are not filled in by a good defense. We also see a lot of feelings of familiarity with the case or the victim. So people are saying, the jurors are saying something like, this happened to a friend of mine. In one of these cases, the juror actually knew the victim. Small town. He's saying, I didn't know him incredibly well. I didn't know him personally, but I definitely knew him. He was a man that we knew in the town. And that feeling of familiarity with the case or something is another way that they fill in that gap when they don't actually have solid evidence or a defense story. So both of these juries were unusual. In the first one, you had a pretty diverse jury, and the foreperson was a Black woman. In the second case, it was all white, but it was 11 women and 1 man, and he was the foreperson. In terms of how they got along, they actually report very little disagreement or reluctance in their narratives. They report a slightly lower degree of certainty. They express few regrets in either their narrative or the closed-ended question, which is the same as jurors on other cases. And and they largely reported that they got along well. They took their time. They were open to disagreement. They talked about things, and they were respectful towards each other. So this is in case number 2, where the innocence is very clear. They reported little disagreement or reluctance and a high level of certainty regarding the guilt and punishment decisions. The quantitative results, which are just there to the right, reveal that these jurors on the whole, minding that this is 8 total, are less convinced than other jurors interviewed. But they did feel that it was straightforward. They had a lot of confidence in their decisions. You can see on case 2, juror 4 says, if ever there was a man that got a fair trial, this was the man that got a fair trial. And so finally, there's a question they're asking about regrets. You know, when you think back about serving as a juror on the case, is there anything you wish you'd done differently? And across the board, they just did not express regrets. You can see the quantitative results on the right. It's 12.5% for the exonerated jurors and 13.5% for the other jurors. And one of the jurors says, I guess I wish I'd been more familiar with the system to be able to understand the terminology. So that is all I have, and I will stop sharing and wait for questions.
Fantastic. Thank you so much. We'll move on now to possible sources of arbitrariness in Indiana capital murder cases.
I will go ahead and share my screen for that then.
Alrighty, and a quick reminder for folks while she's getting set up, you can ask questions at any point. Click the Q&A button down at the bottom and type in your question. We will answer those after our presenters have presented, but you can ask them at any time.
Okay, we're going to get started. I'm Marla Sandys, and that's Lisa Moore over there. And as you can tell by the title, we're talking about possible sources of arbitrariness, and we've got the parentheses on capital, as you'll find out why in a moment. So this project really began in response to U.S. Supreme Court decision in Gossipy Gross. And as people may be aware, that was a case that really was looking at the constitutionality of using midazolam as a drug in lethal injection. And while the court ultimately decided that it was not unconstitutional and that they could, continue its use, really, I think from our purposes and for the purposes of this particular study, what became much more important was the dissent in that case. So Justice Breyer, and rest in peace, Justice Ginsburg, was also on this particular dissent, really took to task the idea of the constitutionality of the death penalty. In effect, what they looked at was not so much midazolam at all, but they basically said, is it time for us as a society to engage in an assessment and evaluation of whether capital punishment as a whole remains constitutional? And basically, they seem to suggest that our approach to date has really been focused on looking at questions at the margins, and that it was time to stop looking at the margins and to directly ask the question. And what I think is interesting and a little bit unique about their dissent is that they articulate the kinds of evidence that they would like to see from various jurisdictions to speak to issues of arbitrariness, cruelty, lack of reliability, and the like. And so, as you can see on the slide there, they articulate some very explicit areas that would be in need of, or that they would appreciate seeing data. What happened there was, in response to that, no great surprise, both attorneys and social scientists across the nation started looking at issues. They had been looking at these issues. It's not as though it was new, but they took a different eye at looking at some of the questions and issues that were raised in the dissent. And so I ended up getting a call from an attorney up in Indianapolis saying, hey, would you mind coming up and talking about this particular issue and see if there's something specifically that we could look at, or some data that we might be able to contribute to this discussion. And when we met with the attorneys early on, their initial research question dealt with the broadness of Indiana's death penalty statute. So in particular, what they were looking at, and I don't expect anybody to read this or be able to and the like, but Indiana has 18 plus multitude of subsections of statutory aggravators. And so their thought was, is Indiana's death penalty statute arbitrary in the sense that there's no real limiting factor to it, that any case, any murder in the state could in effect be charged as a capital crime? And so that was their initial question. I'm going to turn it over to Lisa to talk about how we went from that to where we ended up.
Yeah, so with Justice Breyer's dissent in mind and this pretty long list of statutory aggravators, our research question starting out was asked if Indiana's statute was so broad that it failed to narrow the class of murders that were eligible for a death sentence. So we started the research process and determined what we would include in a code book by just talking with those attorneys that handle death eligible cases and looking at information that we thought would be relevant to our research question and asking if there is arbitrariness in this sentencing. And we also looked at what we would be able to glean from publicly available data online. So it was definitely not a linear process. We had went through many iterations in the code book. We went back and changed some things, did a lot of inter-rater reliability checks in weekly meetings before we were really comfortable enough with the code book to move on to start coding cases and see what else we could do. So our sample was a list from the Indiana Department of Correction that we got on a given day in September in 2017. And this comprised 632 individuals that had been originally charged with murder. So this wasn't that they were sentenced, they were originally charged with murder. We also included the 97 defendants that were sentenced to death or currently on death row in Indiana. And some of the sources of data that we looked at that were publicly available was the Indiana Department of Correction website and Indiana My Case, which had court information and sentencing date information on whether they had a public defender. And we also used, some counties did not have their information on Indiana My Case, so we used their county court information. Additionally, we thought some information about the circumstances of the murder and maybe some victim information would be helpful. So we also used news articles and different media outlets and obituaries to look up that information as well. So the next couple of slides I'm going to show you are maps that just show the dispersion of the murder cases across the counties in Indiana. So I'm going to show you a couple of different ones. This first one is a map of the 632 cases that we got from that given date in 2017. And as you can see, in most of the counties in Indiana, there was at least one case, and the ones in the darker blue had more cases. So that's the one in the center is in Indianapolis, and the one in the northern corner is near Chicago. So the second one represents all of the death penalty requests by county from 1990 to 2018. And as you can see, there's a lot less death requests than there were all of the original. These aren't comparable timeframes, but it just gives you an idea of there are a lot of possible cases that were originally charged with murder, but there are significantly fewer death penalty requests. Also, this shows a similar trend. This is the map of the 97 inmates who were sentenced to death in Indiana, and this includes those that are currently on death row. And as you can see, it's even less. And finally, this is the map showing those that are currently on death row right now. It comprises 9 cases in 8 counties, in 7 counties with 8 people. So Marion County has 2 cases and Floyd County has 2 cases, but they're both for a single person that has 2 different capital cases. Also in Johnson County, the defendant there has recently been found incompetent. So finally, these are just all of the maps side by side. And the key thing of importance to look at here is looking at the first map compared to that last. The progression to get there, it suggests that there could be possible arbitrariness in sentencing based on the location. If you just look at all of the possible murder cases that could possibly be death eligible, and you go down to there are only these few on the side, and why is that? So go ahead and turn it back to you.
Okay, so while Lisa was showing us all the information on the maps, what became abundantly clear to us is that we really didn't have the access to the information to be able to answer the question that the attorneys were interested in. Because out of those 18 plus statutory aggravators, what you find is many of them are not distinct crimes per se. And so the public information that we had, if you go to my case or what have you, it would list an additional crime that was committed. It may not include, let's say, if somebody was like lying in wait, they're not going, that's not listed as a specific crime. And so we realized that we had a really tough time determining which crimes would have been in fact eligible for a sentence of death. But in going through the data, one of the things that just became so abundantly clear to us is that these murder charges were not sticking. I mean, at all. And so what you can see here is of the 260 cases that have been coded all the way through at this time, we have discovered that 85% of those cases, the murder charge has been dismissed. And so that just sort of blew us away in terms of findings. It's not so much what is whether prosecutors are seeking a sentence of death, but rather what we're seeing is that they're overcharging in these murder cases. And the way in which these cases get resolved is primarily through the voluntary manslaughter. In the next slide, you can see that when it was dismissed and when it wasn't, you see comparable percentages of cases, but it ends up being voluntary manslaughter. You can see that in the cases where the murder charge was actually dismissed. You can see the robbery, which of course in our mind would be the ones that would be a death eligible offense. But some of these others were really difficult to know for certain, even though we tried to keep track of statutory aggravators when we could. The other thing that I would say here that was interesting was that I can't say it's in every single case, but neglect of a dependent is cases where children were murdered by typically their parents or caretakers. And so it's not as though all of the cases are they're not, even though the murder charge is being dismissed, it's not as though people are not receiving serious sentences, but clearly when you have, 85% of the cases are resulting in murder charges being dismissed, there raises the question about overcharging. So in terms of our, overall discussion regarding our findings, there seems to be something going on in terms of the geography. Now, whether that's a function of timing, whether that's a function of the prosecutor who's been elected at that particular time, changes in the law and the like, that still remains to be seen. The history factor that we're talking about is that the requests for the death penalty have just plummeted in the state. We had some original data that looked at it through 2008. And when we looked to see the additional death penalty requests that had consisted, since that time, there'd only been 3. And so where that had sort of followed through. And so death penalty requests are plummeting. Then that's because primarily of life without the possibility of parole, obviously being an option. And also this idea of CR 24, which is Criminal Rule 24, and the costs of capital punishment. In Criminal Rule 24, it talks about both costs and payment for attorneys and the like. And so between options of life without the possibility of parole and the costs incurred, I think we're seeing a tremendous drop in requests for death penalty. And then just broadly, our primary finding at this point is the role of prosecutorial discretion in overcharging. To have 85% of cases having the murder charge dismissed suggests that there's something else going on in these cases.
There were some limitations that we ran into, some challenges with this. So there was a little bit of messiness with the data, especially because we are using that public information. And particularly when we were trying to get more information about the cases. So sometimes, as Dr. Standings was saying, it's difficult to know what statutory aggravators would apply. So that's where that information about the cases would be helpful, and where we turn to some other publicly available data like news sources. But that is not necessarily consistent all over. So that was definitely a difficulty. Also, we had a lack of access to transcripts because we were trying to do this with publicly available data, and those transcripts would have been helpful for more information on the court information. I think that is all we had.
Yeah, you guys are running up on time.
Perfect.
So we are done with that.
We do have, thank you so much to the panelists for your presentations. I'll remind attendees that you can hit the Q&A button down at the bottom. It's roughly about there, and type in a question. We do have a question. Has anyone on this panel considered asking jurors how much, if anything, they know about jury nullification? Or if the jurors were aware that should one person hold out, the death penalty cannot be given? There's a lot of talk about reluctance and guilt. I'd be interested to see whether they knew about their rights as jurors.
I've been thinking about this. Can I comment first?
Yes, please do.
So I should say that my involvement with CJP also involved my dissertation work, where I read through the qualitative data where jurors described, the substance of deliberations. I was looking specifically for how gender came up during those discussions and like gender dynamics of the jurors. But in the pursuit of that, having looked at how those interactions occur, the fact that jurors fundamentally misunderstand some of the basic instructions that we give them about how to treat evidence and mitigation and aggravation, I am not convinced that they are well versed in what jury nullification is. Good defense attorneys know that they need to essentially train jurors on that as early as voir dire in capital cases, and will try to tell jurors that this is your individual right. You have that ability. If you've got a particular verdict in mind, you can hold on to that. It's your own individual moral judgment, but the lived experience of what that process looks like behind closed doors and how they experience it in real time is fundamentally different than that, and requires a level of personal resolution that only sort of a small segment of individuals are going to be able to make it through voir dire with a verdict intact that isn't in line with the majority. So, I guess that's just to say, having served as a juror consultant in capital cases a number of times, I haven't heard attorneys talk about that other than to say, if you reach a certain punishment decision, you can hold it, it's your own. But, looking at the data for how that plays out in the dynamics of the jury's deliberations does not have me very convinced that they are either aware of or able to hold on to that.
I'll just add another couple of points, and those are wrinkles for Indiana, actually. There is a pattern instruction that the jurors receive that tells them that they are the triers of both the facts and the law. Indiana is a nullification state, and they receive that instruction. Whether they understand it, I doubt it, because they don't understand many of the instructions. So that would be one thing. The other thing is that in Indiana, believe it or not, a holdout is not necessarily a vote for life. And so it's a really unique kind of situation. I think we're only us, and I think Missouri may be the other state, where if so long as the ring factor has been met and it goes to the jury and they've decided on the statutory aggravator, it can go to the judge. And so one holdout, even though the attorneys, as Heather was saying, the good ones will be saying, you need to hold out, you need to hold out. That alone does not necessarily result in a life sentence.
We have another question. For the third presenters, has it been considered that in counties that have the largest number of death eligible cases, the counties simply don't have resources to handle so many high stress, high resource cases? Curious whether it may come down to offering plea deals on cases with weaker evidence and moving forward on stronger ones.
You want me to take it? Lisa, I couldn't tell if you. Oh, okay. Yeah. I mean, I'm sure, you know, I think that's true in any jurisdiction. I think, you know, that's why I was saying I think a lot needs to come down to deciding, or I shouldn't say deciding, figuring out how prosecutors are using their discretion. And it would make perfect sense that they would go with the stronger cases. However, and thinking a bit in terms of capital cases, you know, Indiana again has these weird situations where you can get the 50% back from the state, and there's all these kinds of negotiations. So I think a lot of it comes down to the tax basis of the particular jurisdiction. And yes, I agree that attorneys are always making those kinds of decisions as to which are the cases that they think they be most likely to prevail. It just strikes me as a little bit odd more that they're going for murder so often and perhaps not seeking death. And personally, I don't think it's all that unusual that they're not seeking death, both for the cost and discretionary issues. But again, in Indiana, it's very weird things I'm starting to realize in Indiana that they, you know, the requirements for a life without the possibility of parole sentence are the exact same as they are for a death sentence. So why not, if they're convinced that they're going to be able to, you know, not incur the cost, go for life without the possibility of parole. And I think that would be the next sort of level to this, is in what cases are they seeking life without the possibility of parole as a distinct sentence, as opposed to just the life, like seeking death as the requests. And that may be that middle ground between we're going for murder, you know, we don't have sufficient evidence to go for that. Now we'll go for life without the possibility of parole, and then, or death in the most extreme cases.
And probably the last question that we have time for, also for the last presentation, did any of the cases studied examine if the people tried with murder or capital punishment had issues with mental illness?
Oh, the only reason I'm kind of chuckling is because a few of us here are working on this manuscript right now, looking at, we've written one and written another one on mental illness and the death penalty. You know, I'm a little bit surprised at how infrequently that was mentioned in the cases that we looked at. And that may be a function of the fact that, you know, prosecutors using their discretion are kind of recognizing that that's a mitigator in that particular case, or that it doesn't make sense to seek murder in that particular case. But the cases where that we saw, though, I didn't see that many that I think of where mental illness was really paramount.
Yeah, I can't think of many off the top of my head that I had coded that had that involved in it. There were maybe a handful along the way that we talked about, but a lot of them that I can remember either had it mitigated down or something of the like, where their murder charge was dismissed in some way, as far as I can remember.
Yeah. Yeah.
Well, I think we're going to have to leave it there. I would like to thank our panel for a very interesting discussion and for the work that they're doing in a state that I used to live in, Indiana.
Oh.
It's a very, you're right that it's an interesting state to live in for sure, particularly as it relates to this issue. Thank you so much for sharing your work with us. So this session will be available on YouTube shortly. We're getting those up as quickly as we can. It may take us a couple of weeks to actually get that done. If you want to be the first folks to know about that, you can subscribe to our YouTube channel. Just search for CrimCon on YouTube, or you can register for our mailing list at crimcon.org. For folks who are looking for the next session in this stream, I'm going to end this stream. It's going to kick you all out and you'll have to come right back. So I just wanted to let you know that this stream will be ending, and then it'll start again here in just a couple of minutes. Okay. Thank you again to our panelists.
Thank you.
Bye, friends.
Bye.